me start my video so you can all see me. Hi, everyone.
So we've had a little bit of a confusion in the links that we've sent over. We're just getting everybody the correct and updated link in a few minutes. And they're going to join. So let's just kick off. Thank you very much for joining. And there's been an exceedingly high amount of, demand for this session. And I really want to say thank you, Lina, for organizing this and actually, giving us the support in helping you with this as well. I want to leave the stage for you to introduce yourself. So I'm just going to do a quick intro for It's Her Way. And then the stage is all yours. So It's Her Way, for those who don't know, is a platform for female entrepreneurs, supporting female entrepreneurs like Lina and many others to enable commerce, community, and collaborations. We have about 2,200 female entrepreneurs on It's Her Way as we speak. We are regional and we're growing within the UAE every day. We launched our business in 2017, so it's been 5 years since we've been in business, and thankfully so we've been able to tide the biggest wave the economies of the world have faced, which is COVID, and our shepreneurs as well have tided the wave with us. So it's a very exciting year and a very exciting next set of 6 months for us. We're seeing a huge amount of momentum. There are growth plans, and we will be launching into multiple markets in the next few months. So if there is anybody in your network who's a female entrepreneur who needs to start and get support, please let them connect with us, and we'd be more than happy to grow with them. Thank you very much. Lina, over to you.
Okay. Hi, everyone. So I'm just going to introduce myself. My name is Lina Hariri. I'm an HR consultant. I run Ask HR Consultancy Services, and I provide HR support, labor law support, anybody who would like to have their HR audited. I can do that for you, or even set up your HR if you don't have something, especially if you're an entrepreneur or a startup, you haven't got anything and you are not sure what you would need. Not just recruitment, but also handbooks, policies, contracts, offer letters, all legally binding documents. I can provide and help you with that, but I can also help you with queries from your employees and things like that. So this is a little bit about me. So let me now start the presentation. What I want to do today, I'll talk you through some of the changes that happened within labor law, and ask questions if you don't understand something, or if you're unsure or something like that, or if you just want to ask a question, please do so. Right. Okay. Let me share my screen. Okay, I hope you can all see my screen.
Yes, we can.
Fantastic. Okay, so okay. Why? So let's talk about the new labor law. So what I want to talk to you today, as I said before, is I'll talk you through to some of your changes and answer as many questions as possible. Of course, I can't answer everything, but I can always answer them later on. You can always ask me, send me emails, messages. My contact details at the end are mentioned at the end. So why? So in February, the labor law changed. So they had a big overhaul. It's basically because, the law was so old. It was from the 1980s, and we really needed something, something new, a bit more modern and, up to date, to be honest. I know that, DIFC had already changed theirs, and it was high time that we did on mainland. We did that, as well. We talk about, it's addressing flexible working options, discrimination, annual leave, gratuities, and many, many other things. I didn't go far enough to my opinion, but you know, it's a very big start. So yeah, let's continue. So the first couple of changes are all around equality, bullying, harassment, excuse me, and non-discrimination. So what I've done is I've given you the articles, and I will share this presentation, excuse me, with everyone. So you have a bit of a, you know, documentation afterwards. So basically Article 4 talks about that it's no longer allowed to discriminate on the grounds of race, color, sex, religion, nationality, social origin, or disability. Now, what that means is, for example, if you are recruiting, for example, and hold on a second for me. I'm just trying to get somebody in the room. There we go. So if, for example, you want to recruit somebody, you can't mention, for example, their nationality, if it's female or male, social origin, you know, you can't do that anymore. So that's against the law now, and it's written in law. It was always talked about previously, but now they will fine companies that are found out to do that. There's also equal pay for women, where they're doing the same or other work of equal value as male employees. We'll have to see how that actually works in real life, and when actually, you know, the labor court will do something about it. We'll just have to see what happens. So far, I have not seen any cases, but I could be wrong. I haven't heard any. Article 14 talks about, for example, you can't terminate someone who's pregnant or on maternity leave. You have to wait until they come back. Also, it prohibits sexual harassment, bullying, and that, I mean by that verbal coercion, threatening physical or psychological violence. So even if you're, like, say, your manager is bullying you at work, or you know, they are definitely not allowed to do that. So next page. Any questions so far?
Lina, quickly, just to help you with this, can you give me the co-host access so I can have people invited while you're talking, because it might be for you.
Yeah. Let me just try and find that for you. Where would I find that?
In the participants, you can just click on look at
participants, yes.
And in more, make co-host on my name.
More. Let me just find that for you, because mine is slightly different than yours. There we are. Make co-host. There you go. Sorry about that, guys. Right. Okay. Right. Article 6. We're hiring. That means anybody hiring. Now, previously, and I know that it's still being done, when you know, employees are getting hired, they always start before they have a work permit and you know, a visa from the company. Well, the Article 6 now said you're no longer allowed to do that. It's interesting because we don't know if there will be any penalties. So at the moment, you know, and we know you can't, because work permits and all of these kind of things take a while to come through. So and employers can't usually, you know, wait that long. So employees are always sort of, you know, employed, and they always start without the work permit. I just say just be cautious about this. We'll have to see if there will be any penalties about, you know, hiring somebody without a work permit. But of course, if you are working without a work permit, you have no protection by court, by the law or by the court, because you're going to be basically working illegally. So, you know, try and be careful on that and on that side. Also, and you all know that, the employer cannot charge the worker or collect from them the recruitment or employment costs. What I mean by that is, for example, if somebody leaves in probation or in the first year or any time during, they can't recoup or, you know, take back the visa cost. So no, same with the medical costs, not allowed. So that's a very important point. And I know employers are still doing it or disguising it, but yeah, definitely not allowed anymore. Well, it was never allowed anyway, but now it's written in the law. So these are changes actually to the models of work. And that, what I mean by that is there's now a few different options, and there are many, many more options. There's full-time, part-time, temporary working, flexible working, and even job sharing. Now with these different types, full-time, you all know, is you work for one employer. Part-time, you could potentially work just part-time, just condensed hours, or you could even work for two separate employers, but part-time. Again, with these part-time, interim, and job sharing options, we're not quite sure who will hold the main visa, who's going to, you know, who's going to be paying for the annual leave, the gratuity. All of these options are still not quite clear. So watch this space on these kind of options. But yeah, there's definitely a lot more. Of course, there's freelancer, there's consulting, there's many more options now. Employment contracts. Now, this is one of the biggest changes that we have. This is Article 8. Previously, we had two different types of contracts: unlimited contracts and limited contracts. Unlimited, they didn't have an end date. Limited contracts were limited to a certain time frame. Usually, they were given to project managers or specific employees that were doing specific tasks, and that had an end date. Excuse me. Now, this has now been replaced. So they're no longer the two options. There's only one option now, which is the fixed term limited contract. And the contract can't exceed 3 years. So when somebody is hiring or you're just starting, your first contract is always 3 years. What happens after that 3 years? So maybe a month before, you can sit down with your manager and say, look, you know, can we talk about my duties? Can we talk about my salary? Anything sort of to do with your contract terms. You could review them, or you just sign another contract for another 3 years or another 2 years, another 1 year, whatever is, you know, is going on at the time. If you don't renew and the contract doesn't actually expire, it just rolls over with the same terms and conditions for another 3 years. Now, because we had the unlimited and limited contracts, employers now have the duty to change all existing unlimited term contracts to fixed term contracts by February the 2nd next year. So, and I'll talk about that a little later. So this is a requirement by law. Probation period, Article 9. So you all know probation can't exceed 6 months from the commencement of work. Now, the only thing, there's a few things that have actually changed now. If an employer wishes to terminate during the probation period, they must give you 14 days notice, not like 1 day and you're out the door. That doesn't apply anymore. In the event, if the employee wishes to terminate during probation, there's a few things. They have to give 30 days notice if they are going to a different employer. and the new employer must compensate the old employer for recruitment or contract costs. What that means is they have to compensate the previous employer the visa costs. Again, I have no clue how this is all going to work, and we are still waiting for some sort of regulation how this is all going to be administered. Now, if the employee wishes to leave the UAE, they only have to give 14 days notice. And paid holiday can now be taken during probation, and it's not deducted when the employee leaves. So they basically are entitled to their annual leave from the beginning. Any questions so far?
Yeah, I've got a few.
Okay.
The one on the limited contract, the new contract is a fixed term contract for 3 years. So my question is an employer not obligated to do a performance review and increase salary for, give an increment or a bonus, performance bonus for the fixed term period? And if there is a factor that is there within the 3 years that, there is an increment in place, does the employer need to renew the contract once again?
This is an interesting question. So first of all, law doesn't state that they have to give you an increment every 3 years or 1 year or 2 years or whatever. It's up to the employer, of course, when they want to give increments. So basically what happens in these 3 years, they're basically the same contracts as before. The only difference is that it's now got a fixed period, so a start and an end date. So when the term finishes, it can be assessed, and you can sit down, as I said, with the employer and say, look, how is my performance? I haven't had an increase. Isn't it possible? I've done X, Y, and Z. I've done really well. I think it's now time to increase, and that's a possibility. So the new contract will have a new salary, and maybe also with new conditions in it. Absolutely fine, they can do that. But if they, if they don't, you just renew on the same terms. There's no regulation to say that they have to increment or they have to change any terms and conditions in the next contract that comes up. And if you don't want to talk to your employer, just want to leave it as is, the terms will, the terms and conditions will just roll over to the next 3-year contract. I hope that answers your questions.
Yes, it does partially.
Okay.
One of the reasons the contract was unlimited and limited, those differences were essentially the way the employee was to be terminated as well at the time, right? So in unlimited contracts, there was more of a severance pay that was involved, and in limited contracts, there was a less severance pay that was involved. So in the 3-year contract, how does the severance pay apply?
So there's no difference now. So basically what you're talking about previously, if you were terminated on a fixed term, on a limited contract, there was a penalty. Those penalties have gone. There's no difference now, and I go into detail on the gratuity payment later on. So that penalty has now disappeared. There is no more penalties on either side if a limited contract is now terminated. Basically, as I said, it's basically an unlimited contract just with a fixed period. That's all it is. I hope that answers it.
Yeah,
but I will go into, I'll go into more detail on the gratuity article.
Awesome. Just reiterating a few things. Everyone who's joined, thank you so much for your time. If you have questions, please pop them in the chat, and I'll be happy to ask them to Lina. And if you want to ask them to Lina yourself, please raise your hand and I'll manage that for you. We have a question from Enid, Lina. Enid is asking, can sick leave be taken during probation?
The sick leave question, yes, this is an interesting one. and I will answer that just a second. Let me just get the information for you, because this is not a straightforward. Previously, you weren't allowed to take sick leave. And I believe it's the same at this time. Let me just find this for you.
All right, while you're doing that, there's another question that pops up in my mind is the paid holiday. Now, within 6 months, within the probationary period, if they take the holiday, what is the maximum amount allowed to be taken? Is it the full term of 30 days? Or is it a pro rata based paid holiday that they can take in the 6 months? The other part of the question, Lina, would be if the contract is terminated, would that paid holiday be compensated by, the payment structure, the salaries?
Yeah, so all right. So for the annual leave, I will talk to you about that in a little bit when I actually talk about the annual leave, if that's okay. So I'll answer that question. I just want to go back to the sick leave. No, sick leave cannot be taken in probation. So that hasn't changed. So it's still after probation period. But I know some of my clients I've worked with, they do actually give sick leave, but it's up to the employer if they want to give the sick leave or not. What labor law always says is just the minimum requirement, but what the employer does, it's up to them. But no, by law, it's only after probation. Okay.
Okay.
Yeah, on the annual leave, let's leave that for a minute until I talk about the annual leave, if that's okay.
Yes, perfect. Please go on.
Okay. So that's a probation. Okay. So so basically, let's talk about the holiday during probation. So yes, you are allowed to take annual leave during a probation. It will be, of course, what happens is, so when you join during the year, of course, you have a pro rata amount anyway, because you don't get, so for example, if somebody joins in August, they will have, let's say, a pro rata amount from August till December. So that will be pro rata, and that's the leave that you are allowed to take. And then from the next year, you will have your full implement. Yeah. But I will go into more detail in the holiday section. So non-compete clauses. Now, these kind of, these are basically to do with your employment contract. Employees who have, this is not relevant for every employee, okay? This is mostly relevant for employees who have access to confidential or private data. And that's where the non-compete clauses apply. And what I mean by that, for example, so if you have access to client data, employee data, employee data, of course, but client data, your employer can basically put this clause into your contract and say that you can't, let's say, work for another competitor because you have access to, client data and confidential data and private data. So the maximum term is 2 years. But usually it's done sort of like for about 6 months. These clauses were always there, but they were never really enforced. But they will be enforced from now on, whereby the employer can actually put these clauses in and ask you not to, basically stop you from going to a competitor, which is a difficult thing to do if you think about it. Let's say, if you have, if you're going, from one vet to another, you know, they are going to say, no, you can't go to that vet because you have, you know, you're going to poach the clients and stuff. Something like that I'm talking about. This will be very, very much regulated now, but the Ministry of Labour, you know, haven't actually said how they're going to be enforcing this. And I haven't been asked to handle any cases. So we'll have to see how these, and if there will be any cases, but I haven't been dealing with any of those cases until now. But just, you know, just to let you know that, you know, new employment contracts can actually have these clauses built into them. And also the Ministry of Labour contracts can have these clauses added to them as well, free zone as well. These clauses can be added, whereby previously, you know, we couldn't really add anything to free zone, you know, for the free zone contracts or the Ministry of Labour contracts. So, but there are actually some certain categories of employees which are exempt, but we haven't been told what the categories are yet. And we are now in what? We're in September, so there's still quite a few outstanding questions concerning some of these, not just the non-compete clauses, but other things within labour law. Any questions on this? Okay. Obligations of the employer, this is Article 13. So one of the things that an employer now has to do is, when you are basically getting your offer letter or your contract, it should now state a housing allowance, unless accommodation is provided to you. So if accommodation is not provided to you, they are obliged to split your salary package, and it has to mention housing allowance. You know, most employers will split out into a basic salary, housing allowance, transportation allowance, other allowance, all sorts of different variations are available to the employee, to the employer, and but it has to be now it has to state a housing allowance. So that's one important change. Also, an employer may not assign work to an employee that is fundamentally different to the work agreed in the employment contract. So if you're employed as a lawyer, for example, but he wants you to work as a chef, that's a no-no. I mean, this is an extreme example, but if there are fundamental differences in the contract, that is not allowed. Now, what the next part is, an employer cannot keep the official documents of the employee. Now, what I mean by that is the passport. And I see it so often still that an employer will keep an employee's passport. That is a no-no. They can have the passport for visa stamping, but then they have to return it to the employee. There's no need, and they have, they shouldn't keep an employee's passport. That is illegal, and you can go to the ministry and complain about that. Also, for example, if you want to leave an employer, you don't have to give them your passport for cancellation. It's all done online. They just need a copy. So it's very easily done. Other things, they have to keep a file, and the file has to have your contract, your CV, your job description, all of these kind of things, any warning letters, salary letters, salary certificates. They have to keep a file just in case there are any cases later on. Everything has to be, they have to be able to prove that they've got all the documentation. They also have to invest in the development of skills of their employees. They have to bear the cost of private healthcare, but it doesn't say what level. So they can provide the lowest level or the highest level, or, there's different levels, of course, as you know, in medical insurance. but you could always request to have a higher category, for example, but you can pay the difference, and that can be, for example, you can arrange with your employee to have this deducted from your, let's say, from your salary every month, but it has to be agreed in writing. Okay, at termination, they have to provide you with a certificate of employment, which says, when you joined, total service, how much you were paid, your job title, reason for termination. Yes, but it's not necessary. It doesn't really have to say that, but it also can say, for example, what your job duties were. Okay, it's sometimes the new employer would like to see something like that. So they are very much obliged to do that. Any questions?
Nope.
Okay, we'll continue. Working hours, as you know, working days, working hours, there was this big discussion at the beginning of the year where the weekend was changed from, Friday to Saturday, Sunday. Some companies I know are still, working Sunday to Thursday. So, the government has changed the hours, but it was up to the private companies to do whatever they wished, really, whatever was best for them. But most private, companies have changed from Monday to Friday. So working hours cannot exceed 8 hours in a day or 48 hours in a week. You're entitled to 1 hour of rest every 5 hours. Or less, that's usually your lunch break. If the employee wants to work remotely, it has to be done with the consent of the employer, but they must set specific working hours. And the normal working hours shall be reduced by 2 hours during the holy month of Ramadan. That hasn't changed really. At first, there was no mention, but in the regulations that came out later, it was actually put back because there were some questions around, what about Ramadan? So it's still in there. Friday is no longer the recognized day of rest because, it's now either Friday, Saturday, or Sunday, whatever, but it has to be 1 day at least. Most companies give 2 days, but some companies do work 6 days. And some companies even give a half day on Friday or give a longer break for the prayer, but that's up to them how they want to recognize the Friday. Payment of wages, deductions, minimum wages. So payment of wages, for the mainland companies has to go through WPS, but they can actually now be paid in other currencies. Interesting, this one. We actually don't know if that actually works or how it's going to work. Your WPS provider would be able to tell you how that would work in principle. Companies should consider, how this is all going to work, if it does or not. Permitted deductions. Now, there was previously always allowed deductions from pay, but now it's only up to a certain percentage of total salary. For example, when somebody leaves employment, if you had taken too much holiday, they are allowed to be deducted from, or any unpaid leaves. They can be deducted from final pay. Any loans outstanding, but it has to be able to be proved and it has to be documented. Any damages that are caused by the worker, they can be, those kind of deductions can be done. It can be done straight away, or it can be done at the end from the gratuity. But again, it all has to be documented. Minimum wage has been talked about for a very long time. This is Article 27. We don't know what the minimum wage will be and when it's going to be introduced. So again, we'll have to wait for that to come through. Now, this is another big change. This is maternity leave, Article 30. So maternity leave has increased to 60 days. 45 days with full wage, followed by 15 days half wage. And there's no longer any mention on entitlement based on service length. So if you are pregnant in your first year, that's perfectly fine. So that's not a problem. That you can take your maternity leave even if you haven't had 12 months service. You can have 45 days extension, but that will be unpaid in case there's any pregnancy-related sickness. Also, you have to provide, of course, documents from the doctor to be able to apply for this extension. Now, nursing of a child, it was previously 18 months. This is now been reduced to 6 months. So during the day, you can take breaks to breastfeed. So that has been reduced to 6 months. Now, in case the baby has special needs, there is another additional 30-day paid leave after the completion of the initial maternity leave. It can be renewed for another 30 days, but that is without pay. There are some other things also, after the death of the child or something like that. So we talked about the breastfeeding breaks. There's 2 breaks, half an hour each. Sorry. So that hasn't really changed, but it's now 6 months. So that's one of the bigger changes within the labor law. Other leaves that have been introduced: parental leave, that's 5 days. So the daddies can take 5 days as well, and it has to be utilized within 6 months. Compassionate leave, paid leave of 5 days in the event of the death of the spouse, or paid leave of 3 days in the event of the death of the parents, grandparents, siblings, children, or grandchildren. Study leave, this is paid leave for 10 business days. And this is basically if you want to have higher education and you're enrolled in an education institution in the UAE. But you have to have completed 2 years of service. So those are the additions to the annual leave. Disciplinary sanctions. Now, this is Article 39 and 40. Disciplinary sanctions. So this is all around disciplinary, and they are very, very strict. The law is now very strict on this. You have to have verbal warnings, written notice, written warnings. The law states that they can deduct no less than 5 days per month from the wage, from the salary. You can be suspended, but not more than 14 days. And also the bonus can be, suspended for a year. No promotion. But it can't be for more than 2 years. And also it could be that the service is terminated. However, end of service gratuity is now being paid. Okay, so that's a fundamental change. Whereas before, if you were terminated on disciplinary, you forfeited your end of service. This is no longer the case. You do now you will get your end of service benefit now. That's a big change. Okay.
Lina, I have a question here. The promotion element again.
Yes.
It says not exceeding for 2 years, but then in the contract we're not entitled. So that's like, it's an overlapping thing, right?
It is, yeah, it is absolutely, yeah. Because promotion is, of course, is up to the employer if they have a promotion, a policy, salary increase policy. Small companies may not have promotions, or bigger companies, yes, of course, like the likes of IBM or I don't know, the bigger companies, they will have those kind of policies, and that's where it applies, but it's not specifically mentioned in contracts.
Sure. Okay.
On suspensions, so the employees can be suspended for 30 days with half pay. This is basically to enable an employer to undertake a disciplinary investigation. So this is all to do with disciplinary process. That's why companies of employees with employees of more than 50 have to have a comprehensive disciplinary policy in place. However, I would say every company should have a disciplinary policy in place because of the warnings and everything has to be documented. So, but I'll come to that in a minute. But for example, if so they are undertaking the investigation, but they are found to be, let's say, not at fault, the employee will be entitled to all their pay after they have been cleared. Okay, so this is another change.
There's a question here.
Yeah.
If an employee is terminated for a disciplinary action and they are on an old unlimited contract, will they still be paid the end of service?
It is, yes. Basically the new labor law applies whether you're on a new contract or an old contract. New labor law came into force in February, and everybody has to abide by the labor law, which is the new labor law. There were a lot of questions at the beginning, how this would work. I'm still on an old contract. No, labor law is now the law, and everybody has to abide by that. So termination of employment. So there's different articles on here. Article 42, it just tells you how an article, how a contract can be terminated by mutual agreement, expiry of the contract term unless renewed, death of the employee, of course, final judgment involving a prison sentence, for example, and redundancy. Now, this is a new one. Previously, this was not recognized by the law. Redundancy was not recognized. So basically what I mean by redundancy, redundancy means either the closure of the business, insolvency, the company closes, or the employer downsizes, and that role is no longer required. That is, that is now grounds for termination. So if the role is no longer needed, an employer is allowed to use redundancy as, a way of terminating an employment contract. Okay. So as I said, the notice period is 30 days, a maximum notice is 90 days, but it's very, very rare that companies have 90 days. It is mostly executives that have that higher notice period. And if the employer terminates an employee, they have the right to be absent during the notice period for 1 working day to search for another job. Now it says here without pay, but to be honest, they're not going to, I don't know, but I have not seen it with my clients yet, where they're actually deducting 1 day's pay. Yes, an employer is entitled to do it, but if they are going to do it, I don't know. It's up to the employer, but yes, they can do that. Now, Article 44 is your previous Article 120. This is your, termination without notice. So when employee misuses his or her position for private gain. So these are just the additions. I'm not going to go through it. The articles the law actually hasn't changed as much. It's just now 44 instead of 120. And these two additions, for example, if an employee works for another employer and they haven't told the other employer, they can be dismissed, so without notice. And as I said before, under this article, employees are still paid their gratuity. This is a major change, okay? Right. For instance, employee cannot be terminated by an employer before exhausting all sick leave. Okay. So basically, this is on sick leave grounds. So basically, they can't terminate you because you are off sick or anything, unless it's a mutual agreement. Okay. End of service gratuity, our favorite subject. So there isn't that much of a change. However, now, as I said before, on a limited contract, there was the differences. There was no gratuity and there was penalties. That's now changed. Also, there was a change where previously employers, when you were terminated, when the employee left a company, the gratuity basically was reduced. That's no longer the case. Termination or resigning or resignation is all the same now. So what it means is between 1 and 5 years, 21 days. After the 5 years is 30 days for each subsequent year of service, but it can't be more than 2 years' wages. So there is no more this distinction between termination and resignation. So an employee can resign and still get their full gratuity. But remember, gratuity is only calculated on basic pay. Okay. 53, what I mean by this article, this is an interesting one. All the employee entitlements are to be paid within 14 days from the date of contract expiration. So basically, when you resign, you have your last day, or even terminate, you have your last day. The employer has 14 days from that last day to pay you all your dues. Okay, now it takes only a couple of days for the company to cancel the visa. It doesn't take weeks or months. It takes usually a couple of days because it's all done online. So there are no excuses there. They can't stop you. But sometimes they ask you to sign something before the cancellation. No. You get your dues first. And within that time, you can have the visa cancelled. Now, there is a new resolution that's just come out, and I know there's a lot of cases currently, and I'm consulting on a lot of these, is whereby companies are saying, we don't have that kind of cash to pay somebody, let's say, 5 years worth of gratuity. Well, the new resolution that has just come out is something, and we are still learning about all of this, is for something like a bank guarantee or protection insurance for employees. This is all to do with private sector employees. So the first option is the company can get like a bank guarantee for no less than 3,000 dirhams for each worker. So again, this is all very, very new, and we don't know how this is all going to work. So ask me questions, but I'll have to come back to you because we are not sure how this is all going to work. The second option would be like a 30-month insurance policy. So basically where the company will pay and the employee will pay something. So then at the end of the employment contract, for example, the money is somewhere guaranteed in a bank account. What some companies do, they accrue a certain amount every year for their employees. of course, you have to have enough cash in the bank to be able to do that. It's like a saving. It's like a saving you put aside in case, you know, because a company has to pay the gratuity by law. So this way they can fund it in a way where it makes it easier for them on a monthly basis to put some money aside. I would speak to your free zone. I'm not sure if the free zones are going to be offering this. So please ask your free zones about this if you're a company owner. Mainland, again, we would have to speak to a mainland and find out exactly how that would work. But I can find some more information on that. And if you want, I can send out an email later on. Any questions so far?
Doesn't look like it. I think it's very clear that we
Okay.
are in new era of labor law.
Yes, I know. There is a few changes, but I think you know, it's the changes have all been for the better, I believe, and company owners have to take note and make sure that they look after their employees a lot more than what they have done.
There's someone who's raising their hand. Let me just unmute them. I am trying to unmute you, Leon. Yes.
Yes. Hi, Lina. Just
Hi.
referring back to your previous slide in regards to redundancy.
Yeah.
I know previous employers have sneakily tried to let go or remove an employee by claiming a redundancy as the reason for it.
Yeah.
Does the law state that should a role be made redundant at that company and the employee is let go because of redundancy reason, can that, is there an expiration date or a limitation as to when the employer can rehire or reopen that position again?
There's an interesting question. There is nothing in law where it states that, unfortunately. There have been cases whereby after 6 months the position was opened again, and employees have taken you know, their cases to court. The employer has to prove that they have, you know, why they have to now open the position up. So it's then up to the employer to prove, you know, are they growing again? You know, why have they opened the position? If they can't, then, you know, the employee will have some sort of compensation coming to them. Absolutely. But again, this is an interesting one because this has not been done before. We don't actually know how this is all going to work. So watch this space on this.
Great. Thank you so much.
No problem. Okay. So what I've done is I've put a few question and answers, and these are sort of questions that have been asked before by, you know, by clients and people that I've helped. So I'll just go through them quickly, and if you have you know, questions after that. Do we need to get consent to change the contracts to the new fixed term contracts? No, it's a mandatory requirement, and employees will need to sign these new contracts. Typically, yes, they could refuse to sign, but once the deadline starts, which is February next year, when they reach the deadline, the new contracts will come into force anyway. Yes, unfortunately, you know, employees really shouldn't, unless there is fundamental problems with what the employer is going to do, of course. But no, they shouldn't be. They shouldn't refuse. Regarding maternity leave, is the 60 calendar days or working days? It's calendar days on the 60 days. Now, if not used, employers will be required to pay all the unused leaves each year. So what that means, if leave is unused in a holiday year, employers only so they can either encash the accrued untaken leave, or they can take some of the vacation days across to the next year, but it cannot be more than 50% of the leave. Okay. So since we have 1 year to change the contracts to fixed term, if someone resigns before the change of contract, how do we calculate gratuity? As we know, the new law applies, so not what the contract says. Can a screenshot of a harassment or discrimination in WhatsApp act as proof? Absolutely. WhatsApp evidence can be used as long as the content confirms the act of the harassment and or the discrimination. Anything that you can prove, screenshots, WhatsApps, but they actually have to show, even if it's bullying or warnings or something like that. Yes, they are part of your evidence. Does bullying fall under discrimination? Absolutely. However, it does, but it depends on what kind of bullying, and has it been witnessed? Have you got evidence to that effect? Do employees need to accept and sign the warning letters? What should I do if he refuses to sign it? Right, so there's no obligation for an employee to sign a warning letter. The employer has to just show that it's been served. So basically by email. So you have to just show that you've sent the warning letter. So it doesn't actually have to be signed. Yeah, it's just the serving of the warning letter.
So if in the case of the labor force, they wouldn't have email addresses, so I believe there would be witnesses involved where
yes, correct.
Okay.
Yes, so I would always, as an employer, I would always ask, take somebody else with me to give an employee a warning letter. If it's the HR, ask the manager to, for the employee, or the manager asking HR to accompanying with the, always have some sort of witness so that you can prove that the warning letter has been handed over. Yeah.
Any questions? There are 2 questions, Lina.
Yeah,
I think.
please.
Yeah. Is the salary of a manager who is also the founder of the mainland company needed to be transferred through WPS? Is it a requirement?
Oh, that's an interesting question. So okay, so the employer is also the owner and he is paying himself a salary. Does he have to be paid through WPS? Actually, I don't know that. I need to find that out. That's an interesting question. I will come back to you. Amin, can you take a note of who's asking that question? And I will find out, and I will get that too.
Lina, it's also Lina who's asking the question.
Okay.
Lina, if you can just send me a private chat with your email address, I will connect Lina on this. I'll connect both the Linas on this.
Perfect. Yeah. Perfect. Where we are. Can an employee force an employee to serve full notice if they're ready to like pay? No. If the employee contract has a notice period of 3 months, for example, the employer can request the employee to serve their notice because it's a contractual right. But if there is mutual understanding, they can leave beforehand. Absolutely. I mean, if it's mutual agreement, sure, why not? And that's it, folks. These are my contact details, my WhatsApp, my LinkedIn profile, my website, and my email address. If you have any questions, if you want to chat, if you are not sure, if you want a consultation, if you want some advice on something, please don't hesitate to contact me. I would be happy, to do anything, where I can help you, if I can. But yes, please do contact me if you need any more information. But this is just labor law is complicated. It's not easy to understand. I try to make it as easy as possible for everyone. There's still lots of questions people are having, but Labour law is a funny subject, and I know there's a lot of cases going on at the moment. But yes, I can see somebody's asking for this. Yes, I will send out, or yes, the presentation will be sent out to everyone. So if
Yes, so the recording as well as the presentation notes will be sent out to everybody who has attended. And for those who have attended via just the link that was shared by your friends or family, please just drop in your email address in the chat so we can send it over to you, because this was a ticketed event where we had captured the database for especially sending this over, as an update to people who attended. But those who've just joined without registering on itsherway.com, we'd love to send this over to you as well. Just drop us your email addresses in the chat here. Thank you very much. Yes, Lina, I've got your email, so we'll send that over.
Fantastic.
Lina, I have one question for you.
Yeah.
I think as a small business, and a lot of us here who have attended the session today are small business owners.
Yeah.
We'd like to know at what stage do we need to have an employee handbook? The struggle is that you're running your business day in, day out.
Of course.
Over a period of 3 to 5 years, we need to have a standard procedure of onboarding the employee and even, saying the goodbyes in a proper way. When there isn't a structure, there might be challenges that come our way, especially when we don't have the resources to hire everybody on a permanent employment contract.
Of course.
So what would your recommendation be for small and medium business owners? And at what stage should they look at, structuring these things from an HR perspective?
Yeah, I mean, for me as an HR person, I think to cover both sides, it's covering you as a business, but also to help your employees understand the rules of the business. You can't have everything in your contract. The contract will be like 20-30 pages long. So have a basic handbook which just talks about for sick leave, for example, when you have to give in a certificate, for example, or they're just the basic things. I think it's for every company to have, but it's not a must. In your contract, you will have your holiday entitlement, sick entitlement, if you wanted to. But if you wanted to be a little bit more structured, then yes, I would say a basic handbook. At the beginning, you don't need to have it. For one employee is not necessary. I think from five onwards, I would suggest to have one in place. It's just to cover the employer, but also to help the employee to know exactly what their rights are and what they can and can't do. Because also you're not going to have let's say an HR person there to, and you don't want to go to a consultant like me all the time and ask, oh, Lina, can you just help me with this? Oh, you won't have the funds to do that at the beginning. So, think about that. Have it in your contract, have the contract a little bit longer, make sure that it is all legal, the contract, it's looked at, and it has all the terms and conditions, for the employees. So I would say, have something in place like a pack, an onboarding pack, a termination pack, something like that. Five employees onwards, I would say.
Perfect. So on top of that question, I would just want you to dwell a little bit on the contracts, because there are, freely available contract templates that, most of the people use in the beginning of the stages. They might not work. However, with the new employment structures that have been, already released by the law, it's become more of a vast space, the way we can employ even startups, even small business. It's a good thing, but also a bad thing if we don't know how to document that employee's, first offer letter or the contract.
Yes.
So what would be the best way what would be like a magic formula if if it's there to say for a permanent contract, this is the way to go, because most people are not even employing, and are trying to employ people with visas now. They are trying to get, that kind of structure where you just get a labor card or a permit. What's your take on that?
Which is perfectly fine. I mean, you can employ somebody on a husband visa, a wife visa, or whatever, or a freelance visa, not a problem. But the contract has to be solid. It has to be legal, because if there are any problems in the relationship, the employer has to make sure that they're covering themselves, but also the employee wants to know that if they have any cases, that the employment contract, they can take that and say, this is my employment contract, and they're not doing what I've signed up to, basically. Yeah, you have your labor contract. Your labor contract is nothing, is one page now. The new labor contract is one page, which is very, very bare. The structure of the free zone contracts are actually a lot better, and they contain all the relevant clauses. So you don't have to have an internal contract, because your free zone labor contract has all the clauses that you want, and you can add to them. So you already that you have a legally binding contract. So you don't always have to have two contracts, a labor and a free zone, or a labor contract, but a mainland contract. But the clauses, if you find contract templates online, they may not be considered as legally binding in the UAE. You get lots of contract templates online that are not legally binding in the UAE. So make sure that you speak to somebody who knows what they're talking about, either a lawyer or a consultant, who would be able to share a contract template with you that is legally binding, because you do need to make sure that is legally binding in case of any issues with an employee.
Yep. Okay, works.
Yeah.
And most of these free zones apparently have their own nitty-gritties
They do.
of the laws as well. So
well, most free zones have their own, but they do follow Ministry of Labour, so the mainland, because this is UAE law. This is not just Dubai law or mainland law. This is UAE law. DIFC, that's something different. ADMG, the Abu Dhabi one is different. However, some of like DMCC, TCOM, I don't know, all these wonderful.
What about RAC? What about RAC, Ajman, IFZA, the new free zones that have been coming up as well?
They will follow mainland. They will follow the UAE Labour Law.
They would follow the UAE Labour Law.
Yes, unless it is stated anywhere, they will follow the labor law, the mainland labor law, the UAE labor law. But they are only, as I said, DIFC and the Abu Dhabi one, they do not.
They do not.
They have their own.
Okay. Just one last question Enid had, and I missed asking you that about government employees. She was asking about, are there any special cases for government employees, or
I don't. Yes, yeah. The government has their own regulations. They have their own labor law, government employees, and I wouldn't even know how that works, because I have not looked into government employees as such. I know semi-government companies do follow mainland labor law, but full government employees have their own, so as far as I understand.
So, and Emirates Airlines is a private entity, I'm assuming, or is it?
Don't get me started on that one. We'll not talk about that one.
Fine. No, so I get it. There are gray areas there, and
there are gray areas. Yes, of course.
Owners, I think we just need to understand how things work. But this was just an FYI.
No, absolutely.
This was an amazing session, highly, highly informative, highly important for every business owner to kind of understand. Even if you're not ready to employ right now, you will be eventually. That's where you want to go. You can't do everything yourself. No. So definitely you need some understanding of how you're going to hire the next resource or your next employee. So I think this was really,
Yeah.
really helpful. I don't
My
think I
pleasure.
know. Thank you very much, Lina. I think
My
we're going to
pleasure.
do a few as well. So yeah.
Okay. Well, if you haven't got any more questions, thank you for attending. And as I said, contact me if you need any help.
Amazing.
Thanks, everyone.
Thank you.
Bye, everyone.
Bye-bye.